So the next area we're going to look at is persuasive precedent. You should be aware, obviously, the definition of persuasive precedent. The definition is it's a law that doesn't have to be followed, but it can be. And one of the things that you'll have been told last year is it's about stealing ideas, right? So you can look at it as a judge and think, do I fancy it? Do I like it? Is that a good idea? And if they want to, they can follow it, or they can just simply ignore it if they want. Right, and there's lots of different forms of persuasive precedent, and again, they might just consider it, or they might actually follow it. If they do follow it, then what you're basically doing is you're turning a persuasive precedent into a binding one. Right, so again, always think about this concept of stealing ideas. Now, again, we've got another acronym for this, and there are 5 different methods of a persuasive precedent, which is sold with a double D. So the S stands for Scottish Court, the O stands for Obiter dicta, the L stands for lower courts, the first D stands for decisions from the Privy Council, and the last one, dissenting judgments. Right. Now, again, with this area, they're generally more likely to ask about the term. So they could ask, just describe persuasive precedent. If that's the case, then you would need to basically explain all 5. Technically, for full marks, it is 4, but I would always say to students, do all 5, because if you get one that's a little bit wrong or one that you miss a case of, then by doing 5, you've ultimately covered your back, right? And to be fair, there's not much that you need to talk about each one. Again, it's the same DFC structure. So basically, your definition of what it is, something else, and then again, as in the whole of JP, it's the cases that are important. So starting off with Scottish Court of Session then. Basically, what this is saying is that we can steal ideas from other countries. If other countries have got laws where we haven't got laws. However, generally we do it from Scotland. We also can do it from other countries, right? And those are countries that are in the Commonwealth, right? Because they're all based on our system. So places like New Zealand, Australia, Canada, potentially we can steal ideas from them, right? Now, you can only do this where we've got no law in our countries to cover it. So say, for example, a judge had a certain case in front of them about, I don't know, contract law. And when we looked at it, we thought, oh my God, we haven't got any law to cover this. The idea is that we can look at other Commonwealth countries and see if they've got an idea. Now, again, you might look at that idea and think, oh, brilliant. So basically you're thinking, oh, nice one. Just steal their idea and follow it into our country. But remember, this is persuasive, so it doesn't have to be followed. It just can be if you want. So you might look at Scotland. They might actually have an area of law that covers it, but you think, actually, I don't like that. I'll just create my own, a new original precedent. Or, if you wanted to, you could steal their idea. A few case examples. Again, you don't need a lot. So you don't need a lot of case examples. A lot of detail, really. So, for example, Donahue and Stevenson. Donahue and Stevenson was remember the snail and the ginger beer, creator of a law on negligence. Ultimately, that case was actually created in Scotland, and therefore we actually stole their idea because we didn't have any law on negligence. We realised obviously that Scotland had, so we stole their idea. Exactly the same as the R versus R case, which again you've already done. So the R versus R case, remember, was about this idea about whether you could be guilty of raping your wife. It was actually Scotland who was the first country within the United Kingdom to say, yeah, do you know what, a husband can be guilty of raping their wife, and we basically just stole that idea. So, the next area is Obiter. And again, you've already looked at this because you've already looked at ratio and Obiter, so it should be pretty straightforward, Right, so obiter dicta then, obviously we know what obiter dicta is. It's by the way comments, so that's your clear definition. Again, just explain how that works in operation to persuasive. So remember, it's all the waffle, it's all the explaining why they did this, how they did that, why they came up with that reason. Any ideas that's in the obiter only persuasive. So again, if you were a judge, you may look at a case as obiter and think, oh, that's a good idea, or this is a good idea, and you might steal it, or you might completely ignore it. Again, what you're doing is, if you do take it on, you're turning that obiter, so that persuasive, into a binding ratio. So, a few case examples that look at this. Then we've got the cases of Brown and Wilson, which you've already covered. So Brown, remember, was the S&M case. So basically, in Brown's ratio, it said, as we know, that you cannot consent to S&M activity. In the obiter, then, they talked about what you can and can't consent to. And one of the things that they said that they believed you could consent to was branding. Right? Now, not long after, we had the case of Wilson. And in this case, it was his wife, and she'd asked as a sign of love and affection for him to brand his initials on her bum. Now, there were no law on branding, whether you were allowed that or not. Right? The only mention of it was in Brown's obiter. Now, that judge in Wilson could have looked at Brown's obiter and thought, well, it says in Brown's obiter that you can consent to branding, but I disagree. So they could have disagreed because it's only persuasive. But what Wilson did was they looked at Brown's obiter, looked at the reasonings and what were talked about in the obiter about branding, and said, you know what, I think they were right. Yes, I'm going to take that persuasive precedent and turn it into a binding one. Right? So turn the obiter into the ratio. So the ratio of Wilson is that you can consent to branding, and that was basically stolen from Brown's obiter. Now, if it is a high court, so say Supreme Court or Court of Appeal, a lot of the time their obiters are stolen because it's obviously high-end judges who know a lot of stuff, and therefore they're quite highly regarded. A lot of the time, for example, our favourite friend, Lord Denning, his obiters were quite often stolen and used in other cases. So the Central London Property Trust versus High Trees, it was in Lord Denning's obiter. A lot of the comments used were picked up later and turned into ratios. Another example is a case, again, we've already done just to make it a little bit easier. We have the case of Howe. Remember, Howe's ratio was that the duress should not be available for murder. In the obiter, they also commented saying that they should think that it shouldn't be available for attempted murder. Now, later on, we had the case of Gotts, which was the 16-year-old boy who was forced by his dad to attempt to kill his mum. Now, again, we didn't have any law on duress, whether duress should be available for attempted murder. The only comment we had was in Howe's obiter. So again, in the case of Gotts, they had two options. They either follow Howe's obiter or they don't. So in the case of Gotts, they decided yes, they thought Howe's obiter was right. So they turned that obiter into a ratio, so turned from a persuasive into a binding, and said that you should not get the defence of duress for attempted murder. Right. Third one then, decisions from lower courts. So obviously, again, this is just due to the hierarchy. So lower courts obviously don't really create binding precedent. They have to follow everybody above. Right. However, say for example, it was Court of Appeal. Court of Appeal might have made a decision. If that then goes on appeal to the Supreme Court, whatever previous decision the Court of Appeal has made is only persuasive, isn't it? Because the Supreme Court is higher up than the Court of Appeal. But they may think it. So as it says on that second bullet point, it is quite common for the Court of Appeal to make a decision, it go on appeal, and the Supreme Court actually go, yeah, do you know what? The Court of Appeal were right, we're going to follow their decision, and again what you're doing is turning a persuasive into a binding. So this occurs in the case of R versus R, which again we've already looked at. So originally we stole it from Scotland, and it was the Court of Appeal who stole it from Scotland. The Court of Appeal said, yeah, it's a good decision, a husband shouldn't be guilty of raping his wife. It then went on appeal, and it was then the House of Lords who turned round and said, do you know what, the Court of Appeal is right. So they turned that persuasive into a binding. Dissenting judgments. Always remember that dissenting judgments means disagreeing judges. So we're looking at top courts. Say, for example, in the Crown Court, you only have one judge in the Crown Court, but top courts, so Court of Appeal and Supreme Court, have more than one judge. So it could be that there's a majority decision, but there is, say, one or two judges who disagreed. Now, those judges who disagree write down a dissenting judgment, which basically explains why they disagreed. So probably one of the good examples is the case of Brown. There were 5 House of Lords judges who heard the case of Brown. 3 said that you shouldn't consent to S&M activity, and 2 actually disagreed and said, oh, we think that you should. Those 2 judges would have created a dissenting judgment, which is a judgment explaining why they disagreed, right? And that dissenting judgment could actually be used later on. So obviously it's the majority that is binding, and it's the dissenting judgment that is only persuasive, right? And a really good example of that, again, is our favourite friend Lord Denning. He created a disagreeing judgment, and that disagreeing judgment was a Court of Appeal case. So everybody agreed apart from him, and he explained why he disagreed. And actually, the House of Lords at the time then agreed with Lord Denning's dissenting judgment and said actually Lord Denning were right. So again, it's turning that disagreeing judgment from a persuasive into a binding. And then the last area is decisions from the Privy Council. Remember, the Privy Council is not in the hierarchy. So it's a special appeal court, or the final appeal court, for cases within the Commonwealth. So high-end cases, say for example in Canada, New Zealand, Australia, other countries within the Commonwealth, sometimes get heard by the Privy Council. Now, why the Privy Council is quite important is because the Privy Council consists of Supreme Court judges, so high-end judges. So we do a lot of the time kind of listen and look and see what the Privy Council has got to say about things, because at the end of the day, it's the same judges who sit in the Supreme Court. James and Karimi, again, we've already looked at this example. James and Karimi, remember, was a Court of Appeal case. And the Court of Appeal should have followed the House of Lords decision in Smith, but instead followed the Privy Council case of Holly. Now, again, effectively, what they're doing is the Court of Appeal are overruling House of Lords. Why can they do that? Well, technically they can't, but the justification is that the Privy Council decision was more recent, so it's more up to date, and also, again, going back to that key point, Privy Council consists of Supreme Court judges, so it is quite highly regarded.